All right. Hi, everyone. Welcome once again to A.O.S. Abroad. Thank you very, very much for joining today's wonderful episode. And I really do appreciate everyone for coming on board. And we don't take it for granted. We appreciate both our clientele and those that are actually joining elsewhere for joining this wonderful episode. Now, today, as the topic actually states, we are going to be talking about a very, very important, a crucial topic at that for anyone that wants to actually work on their immigration, or if, for instance, you have started working on your immigration and you want to avoid the common pitfalls, the common failures of people when it comes to immigration. If you want to avoid visa application rejections, if you want to avoid visa refusals, there's something that categorizes Canada immigration right now, and it's the fact that a lot of things have been changing. I will not say for the worse, but they have been changing for everyone, especially those that don't actually take heed, those that don't actually cross their, you understand, T's and dot their I's. So what I mean is now more than ever, when you are applying for a particular immigration pathway, especially for permanent residents, um, even though others are also affected, you have to be extremely careful, very careful when it comes to, you understand, submitting the application. And today we want to now actually explain to you that if you are to apply for permanent residents, what are the mistakes that you need to avoid? You understand? So IRCC have actually done us a very great favor by sharing with us common mistakes in the PR application, in the permanent residence application. They have showed us how exactly they have seen many applicants, many immigrants making mistakes, making errors, and some of those errors can actually lead to their own refusals. So today being Saturday, 17th of May, we are going to be taking the article that was published on cicnews.com from one of their writers, Janice Rodriguez. For those that are actually joining this live session, you know that sometimes we always come on board to actually decipher and to interpret many of the articles that have been published on cicnews.com. So today is not going to be different. Today we are going to be analyzing the article that was published on May 14th, 2025, and this article actually talks about IRCC sharing common mistakes in permanent residency applications, and also how you can actually avoid it. You understand what you need to do in order to avoid those common pitfalls so that you don't fall into error when it comes to applying for permanent residence. And I'll tell you for a fact that, in fact, people that have been applying or people that have been doing things before, like consultants and immigration lawyers, they too, if they are not cognizant of these errors, they can actually fall, you understand, into mistakes, and you understand, basically lose the opportunity for their clients to actually become permanent residents. And of course, you to yourself, because it is your own application, you have to make sure that anyone you are working with to assist you with your own immigration should actually take note of um all these key areas. So let's really go down into the discussion for today. And before we go on, please don't forget, as we do it, let us know your name, let us know your location, where are you joining us from, and let us know your current level on in immigration. What I mean is, if you have started working on your immigration, if you are just getting started, if you have actually been in Canada for some time, just let us know. You understand who you are. And for me, for instance, I am Aziz Shuduru from Ontario, Canada, and I've been opportunity to become a permanent resident ever since I landed in Canada. May this year, this month actually makes it the second year I've been in Canada with my common law partner, and gracefully we also have an addition to our family units. We have one child already, and that shows that in Canada, you can also come into Canada as a permanent resident and give birth to a Canadian citizen. Do you understand? By virtue of your residency in Canada. But that's just about me. Let me know about you in the comment section. Put your name, put your location, put your status, whether in Canada or outside of Canada. Let us know ourselves. Now, moving on, as we await your introductions, let me also put a kind of give a kind of information. We're on YouTube, we're on Instagram, we're on TikTok, we're on Facebook right now on this live session. And as I said, we are going to be discussing the topic for today: IRCC sharing common mistakes in permanent residency applications. So I have been opportune to apply myself for permanent residency applications before, and I know there are a lot of changes that have occurred in permanent residency applications, and there are a lot of stricter policies that have come on board. So we want to decipher based on IRCC's um, policy changes what you need to adhere to right now. Now, Immigration, Refugees, and Citizenship Canada, IRCC, the body in charge of immigration, for those of you that know about them, they have recently released a training guide for immigration officers. Who are immigration officers? Now, you have to note lawyers that help you to submit an application, they are not immigration officers. You understand? Travel agents that help you to work on some aspect of your travels, they are not immigration officers. Even regulated Canadian immigration consultants, RCICs, they are not what immigration officers. Who are the immigration officers? These are the people that work for IRCC. These are the people that are recruited, you understand, appointed as well to work for IRCC in their offices. So immigration officers like this, they make decisions on permanent residency applications. Do you understand? Now, the document, the 447-page document that IRCC actually shared as a training guide to these immigration officers, they include, among other things, they include case examples of candidates and recommended results following analysis of their applications. So what does this mean? This means that Canada have taken time to explain to immigration officers that, okay, if you see this particular immigration candidate or this particular applicant, you have to make sure that you do these and these, or you take these and these steps, and you checkmate the applications based on some certain criteria. And this criteria is what we want to actually look into now, so that you are well informed that, okay, this is what immigration officers are expecting of your application. This is how they would judge the completeness of your application, the validity of your application, the approval, or again the rejection of your application. Now, based on the examples that IRCC gave on their case, and the various cases they sent to immigration officers, there are some common mistakes that candidates have made that led immigration officers to flag their applications. You understand, for further review or to even reject them altogether. So you don't want to be at a disadvantage after going out through the stress of, oh, maybe for instance, taking language exams, submitting your West educational credential report, you understand, also getting your reference letters from your past employers, just to now find out that at the end of the day, one silly mistake is what caused your application to get flagged and ultimately to get rejected. We don't want that, and that's why we're actually looking into this together with you today. Now, the very first thing that IRCC stated that may be one issue, one mistake that a lot of people, in fact, I remember I had one consultation session with one client and he told me about this. You understand that as a result of that, they rejected his application. And this first thing is using incorrect NOC codes. For those that know what NOC codes mean, they mean the National Occupation Classification Codes. Every occupation you do in this life, you understand, Canada has a particular code, a particular number that has been linked to that particular occupation. So if you're a plumber, you have a code attached to it. If you're a web developer like I was, you have a particular NOC code. If you're a language teacher, in fact, the mistake that I made myself when I started immigrating was using the incorrect NOC code. And that's why IRCC did not even invite me. Thank God they did not even reject my application, but they didn't even invite me for like a year that I started working on my own immigration. Because why? I used the NOC code that was wrong. Instead, for instance, I have always said this times without number that I am a language teacher in the context of Nigeria. You understand? Nigeria, because I graduated with bachelor's in linguistics. You understand? I have French knowledge. I am able to speak French, able to teach English. So, in the Nigerian context, I'm a language teacher. But when it comes to the Canadian context will say you are not a language teacher because you don't hold what we know as a license. You understand, the teaching license. Rather, I am a language coach or a language instructor. Now imagine me in the year 2018 when I started working on my immigration and I put the NOC code for a language teacher. They didn't pick me for like a year since like till like 2019 until I now even have sense after post COVID in the year 2020 to now say, okay, let me change my NOC code. So we don't want that for you. That's why we are saying understand how you can choose incorrect NOC codes. And with what is stated on the article on the cicnews.com website is that when processing applications, immigration officers are trained to look at candidates' job titles. I mean job duties rather. They don't look at job titles mainly. You understand? They don't focus on job titles because the job title you can use. For instance, we have something we call FLE coach. FLE coach stands for French language. You understand? How will I call it? Français pour la langue étrangère. You understand? The FLE coach. So it's basically French as a second language coach. Now you can be using that title, but IRCC recognizes or they have on the NOC website language instructor. Do you understand? So they will not focus entirely on your title because your title can be different. What they call you in your place of work may be different from what IRCC knows about, but they will look at the job duties that, okay, if you say that you are a language instructor, are you performing these particular tasks that a language instructor will perform, even though your job title is FLE coach? Okay, welcome, Mrs. Latifa Takemomi from Ikorodu, Lagos. So they will look at those NOC codes in relation to the job titles or the job duties rather that you are performing. For me, as a language coach, I am teaching language and I am teaching language in a language school. You understand? I am teaching language, helping people to prepare for internationally recognized examinations, helping people to actually register for language tests. You understand? And things like that. But a language teacher is someone that not just really teaches, you understand, the language schools, but is recognized to actually be a teacher in secondary schools, in primary school. So there are some differences that when you look at it, if you go and make the mistake of putting yourself as a language teacher in place of a language coach, you may not get selected. Or if you even get selected, you may get rejected. You may get your application rejected because you fail to actually use the correct NOC codes. So basically, when it comes to the concept of how will I call it? When it comes to the concept of you using NOC codes, you have to look at the duties that you are performing in that job to be able to decipher if that NOC code is what is right for you or if it is not. And you have to verify whether they correspond to the NOC lead statement and the essential responsibilities, not just the job title. That's what I was saying. Not just the job title. You have to look into it that, oh, okay, this job title, even though they are not exact like what you see on the NOC code website, do your duties actually align to that particular work or enrollment? Do you understand? Now, moving on, this means that candidates who submit a NOC code that does not correspond with their job titles or with their job duties rather could see a refusal or a review of the application, especially if the duties align with a lower skilled or ineligible occupation. Just like I told you, different occupations have different codes in Canada. So if you use a code that is not eligible for the program that you qualified for, you may get a refusal. So you have to be very careful. Now, Canada uses what we know as the National Occupation national classification NOC system to identify and categorize occupations based on one, the training that you got, the education that you got, the experience that you got, and the responsibilities that they require in that job that you actually do. So, like in the situation that I gave you, that okay, difference between a language teacher and a language instructor. As a language instructor, I don't need bachelor's or diploma or certificate in education as a language instructor. But when it comes to the education of a language teacher, I need at least a certificate, maybe like a national certificate in education, like NCE from Nigeria, or a PGDE, postgraduate diploma in education, or a bachelor's or even a master's, like bachelor's in education or master's in education, before I can perform the role of what, a language teacher. So you have to look inwardly that which of these educations align with your NOC codes, which of these trainings that you have received align with the NOC codes, which of the experience and responsibilities. So another example that CICnews.com gave us is that, let's take example of Diana from the Philippines. She declared her primary occupation as contact center supervisor. However, upon reviewing her job duties, they were consistent with the occupation of complaints clerk or customer service. Since our duties do not resemble our NOC code position, this affects our ability to meet the requirements, and our case requires further what? Further review. The solution is that IRCC immigration officers will have to research and find the right NOC code based off of their what, of the job duties and the NOC lead statement and responsibilities. Now, for example, take the case of Sam, another person who works for a media company. Sam's official designation is a reporter, which could potentially fall under the NOC code 51113, journalists. However, upon review, Sam's duties include creating blog posts and consulting with clients to determine writing strategy. So based on Sam's job duties, they are more greater. He has a greater fit for the NOC code 51111, which is authors and writers, except technical authors. So if Sam had gone by their designation only, they could have seen a review or a refusal of their what? Of their permanent residency application. So you have to be very careful when you are looking at the job roles. Look at the job roles in line with the job duties, not only with the job titles. Do you understand? And again, another common mistake people make is not declaring changes in circumstances. Now, many times, for instance, I said I came into Canada with my common law partner. Thank you, Brit. I see your like on TikTok. Really appreciate. Now, I said I came in with my common law partner. If, for instance, when I started my permanent residence, I said, okay, I wanted to come alone. Or maybe, for instance, again, I said I wanted to come with my partner. But after some time, my partner was disinterested. And she said, okay, she doesn't want to come again. And I didn't update IRCC that, okay, I was doing it with my common law partner, but now she has actually stopped. Or in the second scenario, I started it myself alone, but after some time, I got to engage with someone and I said, okay, I want to actually, but I never informed IRCC of this marital status change. Because my marital status before was either single and now it is changing to common law partner, or it was common law partner before and it's changing to what? Single. That little discrepancy in my what? In my bio data can lead to what? Rejection of permanent residency application. Now, look at this again. Not declaring your changes in circumstances can be maybe changes in personal circumstances that needed to be declared, but you didn't declare it. So failure to mention a change in circumstances could be seen as what we know as misrepresentation. Misrepresentation is an offense. Is an offense when it comes to the criminal and the immigration law. So you have to be very, very careful, because it has the potential to lead not only to the refusal of your application, but it can also lead to a 5-year ban on Canada immigration. So Canada can actually not only reject you, but they can refuse to actually help you come into Canada for 5 years. And we have seen a lot of people that have gotten 5-year bans. So you have to be very, very careful. Now, example, of these misrepresentations or not declaring changes in your circumstances is maybe in a case of someone known as Amar, who ranks at a lower end of his round of invitation, but he gets a divorce after receiving his invitation to apply his ITA for permanent residence. Now, look at it. When he started, most likely, he started as a married person. His immigration, and you know that permanent residence takes time. It can take 6 months, it can take more time. But in that time, or when he started his application for permanent residence, he was married. But after some time, he got divorced with his wife because of, yes, personal issues, which IRCC doesn't really care about. But what they care about is, oh, okay, your status has changed now. Inform us of your divorce. But however, the divorce causes his CRS points to change. And in this case, it allowed the CRS points to drop. Because mind you, when you are working on your permanent residence, we always say it many times that some of the things that you lack in points, if you have a spouse and that spouse also works with you to work to immigrate, what you lack, maybe your age is above 40 and you are losing points of age, you now have a spouse that actually has a lesser age, and that spouse boosts your own points or boost our own points because she's the principal applicant, you are the secondary applicant. But you never informed IRCC that yes, now you got a divorce and the points that you had got from your spouse does no do not really apply to you again. Because of that, you got a lower CRS point, but you never informed the IRCC. Once they are not working on your application, they now find out that yes, based on your divorce, they recalculated your points and the CRS score is lower to the lowest ranked person that they invited in your round of invitation. In this case, your application is going to be refused due to what? Due to change in personal circumstances. So what's the solution to that? The solution to that is that although it sometimes seems impossible for you to avoid changes because nobody will know that you would have gotten divorced. You understand? When you started your application, nobody knows the future. But it is important for you to be honest and be upfront with IRCC about what? About the changes. One of the very good ways IRCC, especially when you have submitted an application and they have started processing it, is that you have to submit what we know as a web form. You understand? A web form to IRCC stating that yes, when I started, I was married, but now we are going through a divorce and now my spouse is divorcing me. That may mean that you may need to start over again. You understand? Or remove the points of your spouse and now add additional points. Maybe, for instance, during the time you and your spouse were having a divorce, you had gone back to school and you started with bachelor's, but now you got masters. So IRCC may require you to actually work on your WES, your ECA, what we know as an upgraded educational credential assessment. And when you upgrade it, you get additional points, and perhaps maybe they may approve your ECA, your new updated master's degree ECA, to get that additional points that you lost from your from your spouse, if that is possible. Do you understand? So if Amar declares that he declares the changes in his circumstances, he can return to the candidates pool and have the potential to qualify for subsequent rounds of invitation. So that means if he lost his round of invitation, like his invitation due to that divorce, he may be able to go back into the express entry pool and to actually get reselected again for a new for a new invitation. So that's the second mistake that people could make and how you could avoid it. The third mistake that you could make when it comes to applying for permanent residence, which IRCC have seen countless of times, is is number 3, showing inadequate proof of work experience. Now, this is very, very important. Inadequate proof of work experience. Many times people will tell me that yes, I just have, or IRCC just said they require 6 months of work experience, especially for like the category-based draws that people are getting selected for now, right now. And I do always tell people that yes, IRCC will tell you minimums, but avoid minimums, because sometimes that 6 months of work experience you are saying you have, and if we look at it, maybe the 6 months of work experience, because IRCC stated that within the last 3 years for category based job, you should have at least 6 months of work experience. And let's give an hypothetical example. You started working on your immigration in this month, May of 2025, but the experience you used started from June 2025, June 2022 to December 2022. Now, when you started applying for your permanent residence in May 2025, you were eligible because 6 months, you understand, counted within the 3 years period. But when they started working on your application, because IRCC will take their time, when they started processing your application, even though you submitted May 2025, they started around August to process your application. And because they started around August, June, July, August has been deducted from your what? From your work experience eligibility. So as a result of that, you don't qualify because you have inadequate proof of work experience, which was just 3 months that they saw at that particular time in August. So what I do always tell people is that even if they say minimum is 6 months, try to prove more months of work experience, or even at best years of experience. And that's how you hear me say, if an applicant says, oh yes, okay, I'm a caregiver, I have at least 6 months of internship work experience, I say, okay, which other work experience can you use? Yes, that one aside, 6 months minimum, can you add a additional 6 months of work experience so that you will be at the safer side? It's not that when you now get invited, at the end of the day, you now be given invitation, but at the end of the day, you now lose the invitation because of silly mistakes like this. So what we are saying in essence is Canada immigration programs have clearly defined eligibility criteria for work experience. So immigration officers are trained to ensure that what candidates meet all minimum requirements. Canada still will look at the minimum requirements, but many times, if you get more than the minimum self, you will get additional points for the extra requirements that you get. And that extra that you get may be the defining point, the defining criteria that will make you much more eligible than the other what applicants or immigrants who just have the minimum requirements. So let's take another example, just like we saw on the CIC news website. Okay, Rosemary Mariam Yakubu, hello. Oh, okay, you said hello. So hi Mariam, how you doing? Hope you're great. So she said hi on Facebook. So let's move on. Example, Home Kapoor from India had 30 years of work experience as a Bollywood actor. However, upon review, he did not have 1 year of continuous experience in the 10 year preceding the date of our application, as months of his experience took place in for shorter term periods or were voluntary and unpaid. Despite a 30-year plus career, he did not meet the minimum work experience requirement. Now look at this. This is even much more complex. So what's the solution? You have to carefully review the eligibility criteria for your chosen immigration program, especially the special wording around working experience. Now, look at this. Someone has 30 years of work experience, but he failed to see that the requirement of work experience is not just that you can count work experience. No, but make sure that it is continuous. When IRC said it is continuous, that means for like a 10-year period, you were working continuously and there was no gap, no career gap, no work gap between that amount of times you were working, you understand, as a Bollywood actor in this case. Two, it's not just going to be a voluntary work experience that you are just doing as an unpaid internship. It has to be paid as well, that you can show either number one, pay stubs, you understand, or pay slips for it. Two, you can, if you don't have, because some people will say yes, we don't have pay stubs, we don't have pay slips because the company, you understand, doesn't actually have those track records and things. Like, fine, can you get a letter, maybe like a salary certificate letter, as many of us have used, to state that okay, you were paid in cash, you understand, you were not paid in the bank, to actually show that yes, someone can testify to your point, someone can testify to your years of experience, but again, you understand, you have had that experience and you can prove it. So that's the third thing that you need to adhere to. You need to be very careful on. The fourth requirement, or the fourth mistakes people make, is having invalid or expired language test results. Please, you have to make sure of this. This is very, very important. Don't have or fail to have language test results. And in fact, again, I'll use myself as a case study here. I remember when I started immigration in the year 2018. 2018 was the first time I wrote IELTS. In fact, I passed that IELTS. Yes, I had band 8.0, but that time I didn't take it serious. And immigration is not that difficult. I just had to write IELTS once, and I got it. And so I didn't take it serious. Now, in the year 2020, when I was to actually take it serious, when COVID-19 struck and pandemic had lockdown, show me shege in the ancient city of Ilorin, Kwara State. I had to now say, okay, what can I do? How can I work on immigration and things like that? And I started working on it. I found out that my language test result that I had, which was perfect result, was invalid. It was expired. So let's say I said, oh no, it's a lie, Jare. These 2 years that they say is valid is the validity period. And I say, no, I'll use it, Jare, like that. And I go and apply with it. And perhaps I got selected. Let's assume. Even though I got selected and I'm happy that yes, this thing, Canada can still reject my application. Because I remember even that time, yes, that time I remembered that I applied around, the first application I did was around like, is it May or June? You understand? But my language test result was to expire around like October. So if I said that, okay, I still have time now, yes, within May, June, and October, IRCC will take its time. It won't rush to work on the application, to process your application. And they now find out that at the end of the day, even though you had a language test result that was valid when you started, but when IRCC had time to check your application, it was already expired. They can reject your application on that basis. So just like work experience requirements, immigration programs also have specific language proficiency criteria. So in addition to meeting the minimum scores, candidates must ensure that their test results are up to date and obtained from an IRCC approved language testing organization like IELTS, through the British Council, the MOD Australia, the IDP, you understand, MOD Education, and they have to meet the requirements for the type of application they are submitting. So even if you have IELTS academic training results, you cannot use it. You have to get the IELTS general training results. If you have the CELPIP academic, you have to use the CELPIP general. CELPIP academic doesn't work. If you have the PTE academic, no, it doesn't work. You have to get the PTE core. You understand? If you have TEF naturalisation or TEF citoyenneté, you can't use that one. You have to use what? The TEF Canada or the TCF Canada. So you have to note all these things. For example, the 12L IBT test is valid to show English language proficiency for study permits, but it is not valid for those applying for what? Permanent residence. So you can't use TOEFL IBT for what? For immigration purposes. Now, what are we saying in essence? We are saying that language tests that are accepted for Canada immigration, they are valid for 2 years from the date of the test. So your language test must be still valid at the time you submit your application and when they even start processing your application. So example, Laura receives an invitation to apply on November 22, 2020 under Canadian Experience Class CEC, and she submits her application for permanent residence. Her APR was gotten, her authorization for permanent residency application, on December 17, 2022. Look at that too. Upon review, her language scores meet the required CLB level and have a date of December 2, 2018. Look at that. Based on this information, she does not meet the CEC language requirement because her language test results expired as of the APR date. So one of the solutions you can actually do to this is ensure that your language test results are current and they are accepted tests for what? From the IRCC verified providers. You understand? The test providers. Oh, okay. Good question. We have a question from Rosemary Mariam Yakubu. She's asking, can you help me with the journey of relocating to Canada? I am a nurse assistant. Well, that is what we do together with our immigration partners at A.O.S Abroad and with Kesri Immigration. So if you want our assistance, of course, we can always surely assist you. You understand? With the travel services, and our immigration consultant can also assist you with the immigration service. So if you want us to assist you, the very best way, because we get a lot of people asking lots of questions every time about immigration, and the best way we do, I always advise people to actually get to work with us, because we can't work with you without that, is to go on our website. You understand? First of all, get educated on what immigration is about. And that is why we have our webinar sessions that can actually train you, educate you, and enlighten you about all what immigration is about. Then, after that, you can actually go through the next steps that are listed on our website. So, go on our website and click on the link aos.name.ng. You understand, to get all visa informations, to get started with your immigration process, and to actually work with us, you understand, at A.O.S Abroad with our partners. So of course we can assist you, but you also need to assist yourself. You also need to go on the website as we have informed you right now. Go on it, watch the full webinar that explains the step-by-step guide. You understand? If you want us to just guide you, you understand, to do it yourself, you can do it yourself as well. You understand, through our guidance. If you also want to actually work with our immigration partners, you can, and just go through it, understand what we can actually offer you, and once you are ready to get started, on the website, you can actually click on the button to start your process right now. All right, thank you very much for that. Now, moving on. Another mistake that people make when it comes to applying for permanent residence is misunderstanding of the eligibility criteria for immigration programs. Now, it is very important for you to thoroughly understand the specific requirement of the PR, the permanent residency program that you are applying for, as this will help you prevent mistakes. You know, many times, especially our clients that come through DIY, one of the things that we know that a lot of Nigerians, a lot of Africans cannot do or don't want to do is to read, and is to actually study or to watch videos. Some people will complain about their data, which I understand. Data is one of the gold materials, gold commodity in Nigeria and other places. Some people will say they don't have time to read, and that's why many times people are susceptible to scams, because at the end of the day, if you cannot read and understand what immigration is about, people will scam you. Travel agents will scam you. That's why we always tell people, understand the eligibility criteria yourself first. Go on our website, click on the link, understand what immigration is about. If you understand, nobody can come and tell you any cock and bull story. If you understand what immigration is about, and you understand the steps, the guidelines, the processes, there are 15-step process everybody should have to go through when it comes to immigrating to Canada permanently. Yes, some immigration consultants, and you understand, like our immigration lawyer, can assist you with about 10 to 12 steps. But you also need to know what the steps are first before they can now assist you to work on it, before they can now help you to go through the process. But if you don't understand it, you are not willing to go through it, then nobody can help you. You understand? So, example of how you can mislead yourself is like in the case of Austin. Austin believes that he is eligible for express entry through the Canadian experience class. He claims that he has work experience as a research assistant with the University of Toronto from September 2019 to October 2020, and has an employment letter signed by a well-known professor. He was in status from September 2018 to April 2020 under both the study permit and the co-op work permit, and was granted a post-graduation work permit on March 20, 2020. Now look at that. You have to understand the sojourn, the journey of this person. September 2019 to October 2020, he claimed he had the experience. He was in status September 2018. Do you understand? To April 2020. And he also had postgraduate work permit March 2020. You understand? But since Austin's employment listed was concurrent to full-time studies, it does not qualify as work experience under CEC. So what do they mean by that? That even though you were working as a student, that does not qualify, because of course it was a part-time work, and of course it is not one of the qualifying criteria for what? For the CEC qualifications. So in order to qualify for CEC, work experience must, one, be paid work, whether it cannot be volunteering, it cannot be unpaid internships, because that doesn't count. Two, it has to have been gained as an employee. Self-employment doesn't count. It has to not have been gained while you were a full-time student, even if you were on a co-op work term. It cannot be when you were a student. Four, it has to be in tier 0, 1, 2, or 3 of the National Occupation Classification System. And of course, it has to have been gained while authorized to work under temporary resident status. And it has to contain duties that align with the lead statement and the main responsibilities of the NOC code claimed. And it has to be at least 1 year of full-time work, 30 hours per week, or at least 1,560 hours in total. And you cannot count more than 30 hours per week. And lastly, it has to have been gained within the previous 3 years before your application. So because of all these requirements, in that situation, Austin doesn't actually qualify. Thank you, Kayode Adekeye, for liking our live on Facebook. Because of this, Austin doesn't qualify, but he claimed he qualified. So let's say he was to apply based on his own application, he would most likely have been rejected because he doesn't qualify based on the program eligibility criteria. So what's the solution to this? The solution to this mistake is that you have to very carefully review the criteria for this specific program, or better still, consult with a licensed immigration consultant or lawyer to make sure that you avoid these mistakes, because it may be painful. If you have submitted an application and you are thinking you qualify, you are thinking yes, you can apply, and IRCC now tells you sorry, you don't qualify, and as a result of that, you get rejected. And not only rejected, your effort is wasted. Sometimes your funds can't even be actually refunded. Again, you actually wasted time applying for what you don't qualify for. And because timing whilst you are in Canada is more important than timing whilst you are outside Canada, because many times when you are inside Canada, time is ticking. So if you submitted an application that you were not qualified for and IRCC took time to process it, it may just mean that the time that they took to process it, you are now out of status and you would have to leave the country. You have to, and if you don't even leave by yourself, you may even be deported at the end of the day. You understand? Wasting time, wasting money, wasting resources. So you have to be very careful. Now, another mistake people make when it comes to submitting permanent residency applications is overlooking medical or police checks. Don't overlook it, because this is what will lead to what we know as inadmissibility to Canada. Some people are considered inadmissible to Canada under the country's immigration law. And inadmissibility is a big issue. In fact, it can happen due to variety of reasons, including number one, criminal offenses, financial offenses, medical issues, security reasons, or even due to what we know as misrepresentation. So it is important that anytime you are submitting an application, you have to consider that even if a person meets all the eligibility criteria for a particular program under immigration, the application might still be refused on the grounds of inadmissibility. So this also counts for cases in which maybe even a family member, maybe your spouse or your dependent, is inadmissible. Let's take for example, you yourself, you have a clean slate, but the person you are coming with to Canada is a criminal. Oh, sorry. The person which you are coming to Canada has fatal illnesses, not even a criminal. Maybe someone has deadly disease. And it's going to be a huge strain, a huge burden on Canada's health care system. Canada can reject your application on that sole basis because they feel that this person that is coming with you is a person that would take so much money and costing from Canada's healthcare system. Okay, thank you, Funsho Aji Biso. Really appreciate you and the likes. Really appreciate joining. Mr. Yusuf or Mrs. Yusuf. Now, moving on. Example. Let's take an example of someone that can be inadmissible based on medical or police checks. Let's say Mr. Apple is a web developer who meets all the necessary criteria to qualify for CEC jobs, Canadian Experience Class. But upon review of his file, it is discovered that his wife is deemed medically inadmissible due to having weak kidneys, and she has a strong possibility of requiring dialysis in the future. And if you know what dialysis is, dialysis, it takes a lot of money. In this case, Apple is inadmissible under A42 of the Immigration and Refugee Protection Act because he is having an accompanying family member, or even in some instances a non-accompanying family member that he may even sponsor at a later date, because that person is what? Inadmissible. So what is the solution for this? Because yes, we see a problem, we see a mistake, an issue. You have to be aware of the different factors that can lead to what? Inadmissibility. And depending on your case, it can be possible for you to overcome inadmissibility. It can be possible, but of course you have to speak to what? For example, in the case of medical inadmissibility, it is possible to seek legal remedy by demonstrating that the foreign national will not exceed the cost threshold of medical treatment in Canada, or to seek an exception for what? For medical inadmissibility under what we know as the humanitarian and compassionate grounds. So, of course, an experienced immigration consultant or a lawyer can actually help to navigate these complex cases. So, thank you very much, everyone. These are the 5 what they call it, mistakes that can actually lead to refusals or even bans from Canada immigration. For those that were following, the first way that you can become inadmissible or you can make mistakes in your permanent residency application is using incorrect national occupation classification codes for your job roles. You understand? The second one that we talked about is what? Is not declaring changes in your circumstances. If, for instance, you're married, now you're single, or single, now you're married, or you are divorced. 3 is showing inadequate proof of what? Work experience. The fourth one is what? Having invalid or expired language test results. The other one is misunderstanding the eligibility criteria for immigration programs. Even again, there's a sixth one. The sixth one is overlooking medical and police checks. And sometimes me, I can even add my own. The bonus one that they didn't mention here, which can also be an issue, is not having enough of proof of funds. Yes, if you don't have enough proof of funds, not only do they refuse people on temporary residency like study permits, like work permits, like visitor visas, they also reject people for permanent residency applications too. Though it is not more common because many people actually know how to go about that. But is another issue that can get you rejected, refused, or even banned, especially if you even now use a fraudulent what they call it, a fraudulent proof of funds documentation. So you have to make sure that the proof of funds that you require for not just only yourself, especially if you are coming in as a family, or if you even have family back home in your home country, you don't want to come with them yet, but you still added them to your application. So you have to make sure, just like the IRCC website states it, that you have enough funds to take care of yourself within 3 to 6 months, provided you don't get a job. You understand, when you come into Canada or you are struggling and you need, you understand, funds for your accommodation, for your feeding, for your living expenses and things like that. You also need funding for your spouse. If your spouse or your common law partner is to come with you, you also need funding. Even if they are not even meant to come with you, the fact that you added them to your application and they are still back home, you have to show funds for them. And of course, if you have a kid, or at least you have kids, 2 or more kids, up to like 7 or even more kids, you have to also show that you have enough funds to actually cater for them when they come into Canada, or if they are not coming into Canada right now, when they later come into Canada, you have to show funds that you can actually take care of them. And there are many ways to show for funds. You can use your investment, you can use your funding, your savings. Sometimes you can even use the job that you got in Canada before you landed, maybe like a job offer, if you're opportune to actually get a job offer, you understand, to actually show that eligibility criteria being met. So thank you very much everyone for joining. Do we have any questions at all, as we have taken time to explain the mistakes people can make when they are actually applying for permanent residency in Canada? Now, yes, we have talked about the mistakes that you can make when you're applying for an application. This one is different from the mistakes you can make before you apply for a particular program. So let's say, for instance, some people have not even gotten the required World Educational Credential or Educational Credential Assessment, the report. That is a big error. Or maybe you have even gotten it, but in the ECA report, they maybe like World Education Services, WES, for instance, stated that the equivalent credential, the equivalent certificate you got, you understand, from your home country, when they looked at it in Canada, maybe bachelor's is what you have from your home country. But when they assessed it, they said it was not equal to a bachelor in Canada, but they equated it to being equal to a 3-year diploma. And because you thought, yes, bachelor's is bachelor's, and you go and put in your application or in your express entry profile that it is bachelor's you have, but you didn't follow the equivalence of what Canada actually stated on the ECA report that you did as 3-year diploma. Because yes, you thought bachelor's will give you extra points under the express entry, and of course it gave you extra points. You were invited under the express entry or under the provincial nominee programs, you understand, and they now applied, or you now applied for it, and IRCC officers, immigration officers, now checked your application, they checked your profile, and they saw that this salient information was actually mistakenly, it can even lead to a misrepresentation, because they see that you had your ECA report, it showed that your equivalent was 3-year diploma, but you wrote, or you added, you understand, bachelor's when you were filling the forms. That could lead to a refusal and even a 5-year ban, which you have to be very careful about. So Bariro and Mom IFTM, thank you for liking our TikTok live session. So you have to be very careful. Anything IRCC states. Some people, one of the things that can also make you inadmissible when it comes to criminality, you understand, is if, for instance, you have had initially a visa rejection, or you have even had a 5-year ban before, but you now submitted a new application and you never informed IRCC that you got a visa refusal years ago or months ago, or you even got a 5-year ban or 3-year ban, or any case may be, maybe a ban on the provincial level when you did your PMP applications, or a ban on the federal level when you did your permanent residency application. If you didn't put that, that could lead to what we know as a misrepresentation, because you are covering facts knowingly. And because you are covering up facts knowingly, they may actually reject you. Some people may even ask that, oh, do I need to still tell IRCC? Do I still need to tell Canada Immigration Office that I was rejected in France when I tried to apply for study permit, or I was rejected in Belgium when I tried to apply for work permit, or I was rejected in the UK when I tried to apply for visitor visa? For all the scenarios, yes, 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 you need to inform IRCC, even if the rejections of your visas were not from Canada, but were from other countries like US, UK, Canada, Australia, even African countries, any country, because IRCC may have the privilege of getting that information, whether you tell them or not. And if they see that you hid some facts about your particular scenario, about your particular travel history, that you didn't tell them, about your visa application history, that you didn't inform them about before they found out about it, you may actually be facing a 5-year ban, or if you haven't gotten a ban before, they may give you a lifetime ban. A lifetime ban. So you have to be very truthful to telling them that, yes, I was banned before. Now I am reapplying after I've served for 5 years my ban. But yes, I have been rehabilitated. You understand? I've known the mistakes I made in the previous, what they call it, applications, and I'm willing to actually adhere to strict, or to adhere to the visa eligibility right now. I don't take anything for granted. You understand? Show proofs. In fact, there's something we call the explanation letter. You have to write a letter of explanation to show them that, okay, if for instance I had a criminality before, maybe driving under the influence. Okay, I'm in a car right now. You understand? And in Canada, for instance, it's a huge, big issue. It is a criminal offense to drive under the influence. Some people may ask, what is driving under the influence? Is driving under the influence of alcohol, under the influence of hard drugs. In fact, I think I once read in one place where they were saying that you're not even drinking alcohol, not drinking, not taking drugs, but having drugs in your trunk, having drugs in your car, on your car seat, having drugs in one compartment in your car is or can be considered as an offense too. So it's not just about you inhaling drug, drinking alcohol, or doing things, and you understand, having it in your system. If you have it in your car as well, they may actually charge you as well for criminal offense, because you are not just only, you didn't just ingest it, but you are in the possession of hard drugs while driving, possession of alcohol while driving. Another issue, big issue. They can even charge you again with intent to distribute. If for instance the hard drug that you had maybe had some inclinations of you not being only the one that is consuming it, you understand, but having the inclination that you have surplus of hard drugs or alcohol. Maybe for instance it is in your car, and those hard drugs or those alcohol, you are going to share it with other people that are in your car, other, you understand, what they call it, passengers. So you have to be very careful. Driving under the is a big offense. And if for instance you had that offense maybe like in New Zealand, maybe they caught you when you were driving in New Zealand, the country of New Zealand, you now came into Canada, or you are trying to apply for permanent residency in Canada, you didn't now state it that yes, I have been charged with driving under the influence or possession of, you understand, hard drugs or alcohol or things like that. I've been charged in the country of New Zealand. You understand? You didn't state it in your application. You omitted it knowingly or even unknowingly sometimes. That may be a reason for a refusal, and even sometimes a reason for what? For not just rejection of your application, but also what? But also banning for a couple of years. So you have to be very, very careful when it comes to things like that. You have to maintain, you understand, eligibility. Make sure that you know the consequences of actions, whether your actions or even sometimes your inactions, because sometimes you may not do some actions and that may be the reason that you even get rejected. Why didn't you do some action? You didn't take careful, you understand, you weren't so particular in reviewing your eligibility criteria. That may also lead to rejection. You understand? Because when they say in law, there's no ignorance in law. You have to be well informed so that you don't actually fall victim or fall prey of some of these mistakes, and at the end of the day, limit your chances to actually immigrate to Canada. All right, thank you very much, everyone. With that, we come to the end of this live session. Do you have any questions? Do you have any comments? Do you have any clarifications? If you do, please, within the few minutes that we have right now, put it on the comment section. If you enjoyed this, you learned something, like the live session, like the discussion, also hit the notification, subscribe to our YouTube, our TikTok, our Facebook, our Instagram. Do you understand? Hit the notification bell to also get notified anytime we drop a content or anytime we come on live like this. And don't forget as well to always come on live. You understand? For our clients that are joining, you know that at least every weekend we always come on live. If it is not part of the monthly live sessions, we come on live to talk about trending topics and to give you updates about your immigration and what is actually happening in the immigration, what they call it, industry, or in the immigration sphere in Canada. And as well, if you are just joining, please don't, or if you are joining from all our other social media platforms, you are not our clients yet, don't forget to also join us. At least every week we have live sessions at least once a week. And I think this week we have had live sessions for like 3 times. We had one on Thursday, we had one on Tuesday, and this Saturday we also had one. So don't forget as well to always join us and to learn about immigration from our channel. So Rosemary, okay. She said, please call me Mariam and not my full name. Oh, okay, no problem, Mariam. Can a single mother relocate with her kids? Absolutely, absolutely. We have several, a couple of single mothers that are our clients right now that we are helping to migrate. Some are migrating through study permits, some are migrating through permanent residence, some are migrating through visit. So of course, it's very possible for you to migrate to Canada through together with your kids as a single mother. Is very possible. Oh, hello house from Godson Peggy. Hello ma. You are just joining. Thank you. Well, this is recorded, so you can always um watch at a later time. Do you understand? It's always going to be on our channel, so you can go back and learn about it. Thank you very much for joining. Really appreciate. We know that Miss Godson always join our live sessions. So lastly, for any of those of you who would like to always work with us, some people will always reach out to us and they will chat on our channel and say, yes, I'm interested, I'm this and that. If you are truly interested in immigration, if you want to work with us, take the next step. Take the next step by visiting our website to learn about all the visa information you need to know about. You understand? And click on the links to get started with your processing. If you need any more information on that website as well, you can book a consultation with us, and would always be able to actually assist you. aos.name.ng, just like as you can see on the screen right now, is our live session. So don't forget to actually um you understand, reach out through that means. Okay, Bariro and mom on TikTok, IFTM is saying recently IRCC site has a technical glitch. I don't know if it's from my end. I have been unable to create a profile. Well, it's normal. It's normal. IRCC's website always go through some periodic maintenance. I think the last time we logged in, that was yesterday or day before. We saw on the sign up page where they stated that they are going to go through a maintenance. I think that was on Friday. I think they said they were going to do maintenance, whether be on Friday to Saturday or so. So like there's always a period basically that they would run some maintenance on their website. So after that time, you understand, you can actually access it. And if you want to always get the notification, they send the notifications on their website, IRCC secure account. If you go on Google and just type IRCC secure account, you understand, because you said you're trying to create a profile on that IRCC secure account website, the web page, you understand, there's always a kind of bar in on top of it that would always give news articles that, oh, okay, this is the time they are doing some technical changes. And once you go there, you will see that, yes, and once they are done with their technical maintenance, you can always access and create your profile. Okay, thank you so much, sir. You're welcome, Barrio and mom. So but Mariam is saying, I am interested. Okay, if you're interested, just like what we said, go on our website. Everything you want to do, whether be it your visitor visa, your study permit, your work permit, your permanent residence, your refugee or asylum, we have detailed explanations, detailed things on that website. Just go on the website, you understand, click on it, and with that, your interest would be, you understand, would be recorded, and we'll be able to know where to start. And of course, anybody that actually subscribes to our channel or to our website, you would always receive emails. We get tons of emails every day from people, those that are interested, those that want to work with us, those that have actually even started doing the things themselves through DIY. And of course, once you get our emails daily, you can always ask questions even on the email channel, you understand, at admin at A.O.S. But go on the website. Once you go on the website, you'll get access to us every day. We send helpful email messages to people, you understand, and we have people that have been with us for 2-3 years that, you understand, attest to that, receiving our emails every day, learning about immigration, and you understand, learning and also working on their immigration themselves or through our immigration partners. So thank you very much, everyone. We have spent more than 1 hour. I would like to call it a day. So as I said before, don't forget to like, put a thumbs up to this video, put your best emoji, comment on it. Even after this live session, if you get a question, we'll respond to it or refer you to, you understand, useful materials or on information online. And don't forget to also share with your friends and family. Let them know about this immigration pathways and the common mistakes they can actually avoid when working on their permanent residency applications. So thank you very much, and I do hope to see you in our next live session. And do have a lovely day ahead.